A lot more standing up and sitting down than usual. Just give me a sec. All right. For the record, Justice Ditkoff back sitting. The case is 24P 1373, adoption of a child. Again, it's an impounded case. We'll use terms like mother and child. And I'll remind the panel to speak up for this case. Counselor, whenever you're ready.
Good morning, Your Honors. Richard Shokire for the appellant mother. She is joining us via the YouTube channel this morning. May it please the court. Mother is asking this court to vacate the orders and decrees terminating her parental rights and to remand this case for further proceedings. At the lower court, the department presented 26 exhibits and 2 witnesses. The judge made substantial findings, but none of them addressed mother's mental health issues, which became rather prominent, or at least to a consequential degree, in his conclusions of law, of which he made 4. Not surprisingly, there is no analysis there that would support the required nexus that mother's mental health issues rendered her unfit. Nevertheless, the conclusions of law remain unsupported as to the calculus that was used to determine the unfitness. This cannot be brushed off as merely harmless error, as my brother and sister contend in their briefs. Rather, this is reversible error, as the judge attributes mother's mental health issues to her unfitness without any evidence or analysis, or scant evidence. Both the departments and the child's briefs failed to substantively address the error and instead rely almost primarily that this is harmless error or that there are snippets, mostly taken from a court investigator's report, that sufficiently demonstrate mother's mental health issues. However, the judge never refers to any of these whatsoever in any of his findings. This cannot be construed as merely harmless. I believe the department contends that my analysis of Eden is misplaced. However, it is not. In Eden, this court, Judge Rubin in particular, posed the question of what is the purpose of this court when we have unsupported conclusions of law, or I can't remember off the top of my head what he said, improper factors, I believe. And so this is an improper factor, and though it is a narrow issue that's before this court, it can't be simply swept under the rug, and it misses the point. Mother, though the department makes its argument that mother did not participate in mental health screenings, this is not where she is using a shield to defend herself from allegations and then using a sword to say there's no evidence at trial. That's not. Why isn't it? Because it is a misplaced point, Your Honor. The judge finds that mother has mental health issues without any evidence. So it's not that my client views the evidence in a different light than the department or the child. It's that there was no evidence in front of the court where the judge then conjures up mental health issues as in part of his calculus of her unfitness.
So in the judge's memorandum at page 2 in the introductory portion, when the judge says, mother never engaged in therapeutic services or completed a psychological evaluation to address her mental health concerns, are you saying there was not sufficient evidence for him to infer that the mother had mental health concerns?
How could he infer mental health concerns? I would point this court to adoption of Zoltan and care and protection of Bruce. And in both of those cases, which I think sort of elucidate the point of Eden, the judge can't simply say mother has mental health issues. There must be evidence to support it.
Why isn't a substance use disorder to the level your client has a mental health problem?
Well, as opposed to the evidence that was before the court in care and protection of Bruce, there was no expert testimony. There was no analysis within the court investigations report. There was not even one word that was uttered by the two witnesses presented by the department. So we're left with, though it is my narrow issue, the issue of what evidence supported this other than the judge's conjecture that because of her substance abuse issues, she therefore has mental health issues.
Well, the mother's action plan had recommended that she undergo a psych evaluation and have weekly mental health counseling.
It did.
And there's no evidence in the record as to whether or not she did.
That's right, Your Honor. Other than her testimony that she had been meeting with the therapist. But it again begs the question of why would the department have these concerns, and why would the judge then take simply tasks within an action plan and then somehow create mental health issues out of that?
Okay, the record contains a report from the ongoing worker to the court on March 14th. This is at page 220 of the exhibit volume, that the mother told the ongoing worker that she had an appointment with a psychiatrist coming up.
Okay.
Could the judge consider that, or could we consider that for the purpose of showing that the mother's saying then, 4 days before trial, that she had an appointment was too little too late when it had been on her action plan for almost a year?
It could be construed as too little too late. However, I think that we're, again, missing the mark of what the issue before this court is where did the judge get the evidence to determine that her mental health issues impacted her parenting abilities? And again, even in cases like Bruce, we have expert witnesses that didn't even satisfy the spectrum of the analysis.
So what would prevent a parent whose DCF says, we think you should get a psych evaluation, and then the parent just refuses to get the psych evaluation and then says, you can't terminate my parental rights because you didn't prove I have a mental health disorder?
Your Honor, if I can sort of go back to, I'm sorry if I'm being a little circular here, but that is a burden that is upon the department. My concern in my client's argument is that despite all of these, and they're not ancillary issues, but despite all of your questions, the judge simply created 4 conclusions of law that he used, to whatever degree we have no idea, to terminate mother's parental rights. And therefore, I believe Eden is apt in this case of where it actually is an improper factor.
Is it an improper factor because there was no, are you arguing it's an improper factor because there was no finding of fact within the caption of the judge's memorandum?
There's no finding of fact, and there is just a few snippets of anything in the department's 26 exhibits.
But what about the part I quoted from the introduction, where the judge said, mother never engaged in therapeutic services or completed a psychological evaluation to address her mental health concerns? Is that a finding of fact?
I believe that's an introduction, but despite it, but even if we want to play that out in terms of that being a finding of fact, it doesn't really create the finding supported by evidence to allow the judge to make that determination.
Well, the determination is that her mental health is a concern, right?
Yes, Your Honor.
Why isn't it a concern? With the way she's living her life?
It could be, of course, anything could be a concern, Your Honor, but when we are looking at the conclusions of law that the judge came to, what were these based on, and to what degree did they affect his decision? And I think these mirror the facts and circumstances of Eden, and it also mirrors it also is supported by both Zoltan and Bruce in terms of the judge simply conjuring up mental health issues without any evidence.
Could the judge take judicial notice of the idea that somebody with long-standing substance use disorder is possibly self-medicating because of an underlying mental health issue, or conversely, that somebody with long-standing substance use may develop a mental health disorder?
I would say that the judge could take judicial notice. However, judicial notice is not evidence. And again, the burden is not on mother, it is on the department. And even if the department had not produced this evidence, the fact that the judge then entertained this speaks to error.
Anything else, counsel?
No, Your Honor. If there's no questions from Justice Hand, I rest on my brief.
All right. Thank you, Counselor.
Thank you, Your Honor.
I'm sorry?
Are we splitting 10 and 5?
Yes, we are, Your Honor.
All right.
So may it please the Court, Assistant Attorney General Mary Ann Reynolds, on behalf of the Department of Children and Families, asking this Court to affirm the decrees that mother is currently unfit to parent child, that unfitness is likely to continue into the indefinite future, and that it is in child's best interest for her parental rights to be terminated. Mother, as outlined in my brief with sites with record support, child was born with cocaine in his system and needed treatment for withdrawal. A month after his birth, there was domestic violence between mother and her partner. Her mother is an adult who has 2 older children, both of whom were removed. There were substance abuse concerns at that time as well, so long-standing substance abuse concerns. At the time of trial, mother was unemployed. There were domestic violence concerns with respect to her, both as a victim and as a perpetrator. There were concerns about her neglect of her second-born child, who was later adopted by mother's sister, the maternal aunt. Mother's partner was married to another. He lost his, excuse me, he lost his job after becoming unreliable, trying to assist mother. Her partner was not the biological father of child per testing, but mother testified that she nevertheless believes that he is. As mentioned, she was plagued by substance abuse throughout her life, starting back in high school. At one point, her family, Section 30...
Did you say they were married?
Pardon?
They were married? The mother and the putative father? Did you say they were married? I just misheard that.
No, mother was married to the father of her first child.
Oh, okay, I'm sorry, I misheard you.
No, her partner, who for a time was thought to be the putative father, he himself was married to another. And he had been employed, the record shows, but then he lost his job. He became unreliable once he was trying to assist mother. The mother was homeless most of her adult life, living in motels paid for by the partner. She never allowed the department to access a home. Mother thought that her partner was an appropriate caretaker for the infant child. Even though he stayed with friends, he didn't have a place of his own. mother had outstanding arrest warrants. She had an adult criminal history. She was incarcerated at times. She had parole violations. She had convictions for drug offenses, trespass, larceny, property destruction, and as I mentioned, domestic assault and battery. She was non-compliant with her action plan. Her action plan was designed in part to help her learn coping skills and to focus on emotional regulation, to help her with intimate partner violence treatment, to learn about healthy versus unhealthy relationships, to get mental health counseling, and she had a pattern of making plans but not following through. Significantly, she also had indifference to child. She was offered weekly visits, and she did not visit for like the first 11 months when he came into care. Then she visited once in January of 2024 and once in March of 2024. The child, who was reported at the time to be delayed in all areas, has been placed with the R family. His needs are being met there, and he is doing well. So there was a constellation of factors that were the basis for the decrees. And I do submit that mother's mental health is a relevant factor. Her mental health needs went unaddressed. And according to her own testimony, she at times misused substances because she was under stress.
Well, there was evidence that she used drinking to calm her nerves and substance use based on a lot of stress. Is there other evidence besides those two particular points?
About other evidence of mental health concerns or of stress?
Particular mental health, what the specifics of the mental health concerns were.
Okay, thank you, Your Honor. I think that it's important to not conflate. So this is, I guess, a long answer to your question. It's important to not conflate mental health and mental illness, right? There was no mental illness diagnosis specific in this case. She had been Section 35, and she had to go into detox. There was long-standing substance abuse, that's true, which is a mental health concern. But in addition, there is, I think if one says, we do not have a diagnosis, like in some cases we have diagnosis of, I'm not even going to say like bipolar, like we know, like we don't have that type of a diagnosis here. But what we're talking about here is not a finding that she was mentally ill. What we're talking about here is that the judge said that she was unfit in part because she failed to gain an understanding of what her mental health needs are or possible diagnosis. And so the judge was very concerned about her lack of insight into her mental health. And what is mental health? As I noted in my brief, mental health is a state of mental well-being. It enables people to cope with the stresses of life, to realize their abilities, and to contribute to their community, as opposed to mental illness, which is within that realm, but it refers to diagnosable conditions that could significantly impair daily functions. So we don't need a mental health illness diagnosis in this case to understand why the judge, the trial court judge, who heard mother testify on the stand as well, and whose assessment is entitled to deference. It's quite obvious that mother, given all of the factors that I mentioned, the domestic violence, the unemployment, the indifference to the child, the difficulty that she had having housing, that these things are related to one's ability to cope with the normal stresses of life, to realize abilities, etc. And so,
I'm sorry to interrupt you, but is there a case that you can cite to that reads mental health broadly in the way that you're describing it?
Thank you for that question, because, I'm sorry, I'm not sure where I should direct my attention, if it's
Whatever you like, whatever's comfortable.
It doesn't matter, you could.
Whatever's comfortable
I
to you.
look this way,
That's fine.
Okay, thank you. So, no, I could not find a case that speaks to what mental health is like that broadly as I am saying. So what I've done is I've done a customary thing of saying what mental health is as defined in the dictionary. I mean, I think that To my understanding, I think that this is what the trial judge was saying here, is mental health like physical health. Like we understand that there is the capacity of the mind, the regulation of emotions, just as there is physical health.
So everybody has mental health, but not everybody has mental illness.
Correct. That's our position. And so that the court having, wanting mother to have gained insight into her mental health is quite appropriate here, where mother obviously was not functioning well, either for herself or for her child, for her family or for her community. To the extent, and so I think also too, as far as mental health being relevant, it was clear that the department had mental health concerns and was attempting to provide mother with services. Mother was resisting those. I did argue harmless error in my brief just because it does seem that if this court had some concerns, it really would be harmless error, but I don't think you even need to get to harmless error. I think that the trial court did not err, that there's no need to remand this case. The court should affirm the decrees. And if there's no other questions, I'd rest on my brief.
All right, thank you, Counselor.
Thank you.
We'll hear from counsel for the child.
May it please the court. Good morning, Your Honors. Steve Rosenthal, representing the appellee child. The child was 13 months old at the time of trial, and throughout that period, the only time that mother has ever parented this child was during her pregnancy, and that was not a rousing success. She testified, or she admitted, that she was doing fentanyl 2 or 3 times a day throughout her pregnancy. She tested positive a couple of times during the pregnancy and tested positive when she was admitted to the hospital to deliver this child. So her only effort was that. She visited the child twice during the pendency of the case. And the reason that she gave for not visiting the child sooner was because she didn't need to visit the child because she thought her boyfriend was going to get custody. And I've cited that in my brief, and I would also refer the court to the transcript at page 124, beginning at line 16. Now, although this doesn't constitute abandonment as defined in Chapter 210, Section 3I, she virtually abandoned this child. And she is a stranger to this child. The child wouldn't know her if she showed up, if they were both in the courtroom today. I disagree with my brother's analysis of the case. There were 100 findings of fact in this case, and the appellant has not disputed a single one of those 100 findings of fact. And those findings of fact outlined, as my sister stated a few minutes ago, a constellation of factors. There was the drug use, there was a criminal history, domestic violence, unstable housing, probably a couple more that I can't remember off the top of my head. And I think the appellant is trying to have it both ways. The appellant is saying, well, the judge didn't address this one factor, this mental health factor, and for that reason, none of these other factors really carry the day. Well, the problem with that is that mother was directed, one of her action plan tasks was to undergo a psychiatric evaluation so that it could be determined what the status of her mental health was and what services could be provided. She refused to do that. She also refused to sign releases so that DCF could obtain copies of her medical records from a time when she was sectioned and from hospitalizations that took place, either before or during her pregnancy with this child. So she can't have it both ways. She can't say on one hand, well, you didn't address my mental health issue, when she made it impossible for DCF to address that issue and to figure out what, if anything, would be necessary to ameliorate any mental health problems. In any event, whether mother had a mental health issue, and I don't think this is the driving factor in the case, it's the only one that mother has hung her hat on, but whether she had a mental health issue at all is not a conclusion of law, as I think my brother stated. I may have gotten it wrong, but whether she had a mental health issue.
I think he's just saying it was in the conclusions of law section of the opinion.
Well, whether one has that type of problem is a fact that could lead to a conclusion of law. It is not itself a conclusion of law. I'd like to direct the court's attention in the few seconds that I have left to a case that just came down from this court yesterday, its adoption of Breck, which I think in many respects is very similar to this case in terms of the constellation of factors that are involved. But there's one important distinction. In the Breck case, and by the way, my brother here represented the child in that case, here he's representing mom, in that particular case, mother had been diagnosed with a series of mental health issues. Here, mother basically prevented DCF from determining whether mother had mental health issues, and therefore the court had no evidence before it from which to draw that type of finding of fact. If there are no other questions, then I will rest on my brief.
Thank you, counsel.
Thank you.
Thank you all. We will take the case under advisement. All right, I'll call our last case of the day, LESSARD versus Grafton and Upton Railroad Company, number 24P1120. For all you interns, if it was 130 years ago, half the cases would have a railroad in them. So this is really bringing us back to the start. Counselor, whenever you're ready.
Thank you, Your Honor. May it please the court, I'm Leonard Singer, and I represent the appellant, Grafton and Upton Railroad here. The court told the parties to be prepared to discuss whether this case was properly before the court. And in response to that, the land court judge did not make an express determination that there was no just reason for delay. That having been said, certainly an argument can be made that someone should have recognized the requirements of Rule 54B here, Civil Procedure Rule 54B. But I do want to assure the court that it was never part of my intent or the railroad's intent to evade or sneak by Rule 54B. It was just, it was overlooked. So turning to the merits now, if I may, Your Honor, it's agreed that the court's review here is de novo, that there is no deference owed to the opinion of the land court judge, and that the LESSARDs had the burden of proof in the land court and have the burden of proof here to show that the easement that they're concerned with, that we're concerned with here today, is grants them more than farm use. That's the issue before the land court. That's the issue before the court here today. So let me turn to the burden of proof. It is not enough that mathematical chances favor the proposition to be proved. That comes from the Superior Court Charge Book. It was cited with approval in 19 Mass. Practice Series, Volume 19 of Mass Practice Series, Section 102.12.
Agreeing with you on that, counsel, but what we're left with as far as evidence goes is basically the plain language of the easement, correct?
That's what we're left with, is the language of the easement. That's the only thing here. That's correct, Your Honor, yes.
Can you help me understand, even putting aside what the rationale might be for setting the easement up in this way, about which we do not have any evidence, help me to understand why the way the easement is phrased here, an easement and right-of-way not less than 12 feet wide across, with a location, then, comma, imposing a responsibility on the company to keep the land in a suitable and convenient condition for a farm crossing. How does farm crossing relate back to anything to do with the description of the easement? Or a limitation on the scope of the easement?
Well, Your Honor, if you look at the Patterson versus Paul case, there you had language which dealt with the maintenance of the easement, dealt with the clearing of trees and things of that nature. And the SJC said in the Patterson case that when you look at the easement as a whole, although the description of the cutting dealt with the maintenance of the easement, the court said that bore upon the scope of the easement also. So I would cite Patterson versus Paul for the proposition that, yes, it's true that the maintenance requirement, which refers to farm crossing, refers to that, but under Patterson versus Paul, this court, or under Patterson versus Paul, it is appropriate to consider that with respect to the scope of the underlying easement itself. And in Patterson versus Paul, Your Honor, the court found that description of the maintenance requirement was applicable or was taken into consideration in determining the scope of the easement, notwithstanding language, quote, exposing to view any and all, but not limited to the waters of Pleasant Bay and the Atlantic Ocean, along with the islands, marshes, beaches, mainland promenades, which present themselves. So there was language in Patterson versus Paul which suggested that the view easements were substantial, were complete, or whatever. And what the court said was, no, if we look at the maintenance obligation, that we take that into consideration. And there's obviously, well, we take that, they took that into consideration in determining the scope of the easement.
Why
Wasn't that talking about the, no, go ahead.
Why isn't it a reasonable interpretation of this easement language back in 1892 that the that the reference to a farm crossing refers only to the railroad's obligation to maintain it? In other words, for a farm crossing in 1892, I'm assuming it just needs to be a dirt road that's wide enough for cows to walk across. If it was for some other use, like carriages, this is before cars, so carriages and other kinds of transport, there'd need to be much more expensive maintenance. Why isn't that a reasonable interpretation of this document?
Well, Your Honor, the question here is not whether it's a reasonable expectation of the document. The plaintiffs, or the LESSARDs, have the burden of proof here. They have to to show the land court, they have to demonstrate to this court that that is the interpretation that's proven by a preponderance of the evidence. I mean, this is a burden of proof case. This is not, this is just not whether what might be a reasonable expectation. They have the burden of proof. And you know, let me in that regard say,
Well, Counselor, I thought you had a counterclaim for a declaration that they don't have anything more than farm use.
that's correct, Your Honor.
So if you're right that it's a burden of proof thing, can the judge really just say, I won't declare the rights at all, neither side has proved it?
I'm sorry, Your Honor.
Well, so you're saying they didn't have enough proof, but of course you didn't have any more proof than they did. So when both parties want a declaration, what does a judge do in that situation if neither side has established sufficient proof?
Well, Your Honor, I think the counterclaim here was procedural. I mean, the law is clear on easements that the LESSARD, and they don't dispute this, they have the burden of proving the scope of the easement. And the counterclaim for declaratory judgment, a fair reading of that is saying that, you know, they have failed in their burden of proof, therefore judgment enters in my...
I get it. You're not relying on them being the plaintiff. You're relying on them being the easement holder for the burden. Is that right?
That's correct, Your
Okay.
Honor. That's
now.
entirely correct, Your Honor. You know, they say, I mean, the gist of their argument is that the text of the easement does two separate things, and I'm pretty much quoting from their brief at page 9, and that the grant of the easement and the maintenance obligation are disjunctive. That's on page 8. That's the sum and substance of their argument. And they say that, but what is the evidence of that? What is they have the burden of proof of showing that it is disjunctive, that it is, that the maintenance requirement is separate from the grant of the easement. That's their burden to show that.
Can that be proven as just a matter of sentence construction?
I'm sorry, Your Honor.
Sorry to interrupt you, but can that be proven as just a matter of sentence construction? If, in the way that, and I'm not claiming to be an expert in sentence construction, but if we were to read it and say, the sentence says, first, this is the scope of the easement, separately, this is the scope of the obligation of maintenance, and that's the way the sentence is properly read, isn't that the proof?
I submit, Your Honor, you know, they essentially say that when they cited to the nearest reasonable referent canon.
Right.
And they cite to Justice Scalia's treatise on this, on reading the law. But the treatise does not support their argument. What the treatise says in that regard is a modifier normally applies only to the nearest reasonable reference. And that's essentially what you're saying, if I may, Your Honor, is that if you look at this, that the farm crossing maintenance requirement applies only to the that's what you're saying.
That's what I'm asking. I'm posing that as a possible reading.
And if you look at the support for that is that the plaintiff's cite is this reasonable referent canon, citing the treatise. But what the treatise says is that a modifier normally applies. Normally is just like it's is back to this mathematical probability that when I was talking about the Superior Court charge and that mathematical probability is not sufficient, doesn't carry the burden of proof here. And if you look at the treatise, they cite two cases, one in which the court held that the reasonable referent canon applied, and one a Sixth Circuit case in which the court didn't apply the reasonable referent canon. And I've previously discussed in one of my answers the Patterson versus Paul case, where if you look at the referent in that case, the maintenance requirement, it talks about maintenance. But what the court said is that in Patterson versus Paul is that discussion of maintenance also bears upon, it's not disjunctive, it's not two separate things. And that's the LESSARD's argument here. And I'm suggesting to you, I'm telling you that that's just not proof. It's normally, yes, normally that's true, but normally doesn't cut the mustard here. The burden of proof is more than that. One other thing, if I might add, they say on page 5 of their brief, the language being the language of the grantor is to be construed against it. The problem with that argument is there's no factual predicate for that. All that the statement of facts that was before the land court judge and it's before this court is that at the time, all that the statement of facts says about the easement is that the easement from the Grafton and Upton Railroad dated March 24, 1892 to Bridget Coffey, recorded at book 1381, page 528. And they admit in their brief that, quote, little is known about the circumstances that attended the grant of the easement and right-of-way. For all
But there's no doubt of who is the grantor, correct?
I'm sorry?
There isn't any doubt about who the grantor of the easement is. Your client was the grantor of the easement, regardless of who drafted the easement. You were the grantor, correct?
The grantor, that's correct.
Okay.
That is, I mean, that's manifest here, Your Honor.
Okay.
However, for all we know, Coffey drafted the easement. For all that's apparent from the facts here, is Coffey granted the easement.
Counsel,
Can I ask you a question? Oh, no, I'm sorry.
No, please go ahead.
I just wanted to switch topics. So if you're, I wanted to ask an Alberti question. Do you have something to ask before that?
Please go.
Okay, thanks. Counsel, can I turn you back just for a minute about the question about Alberti versus Alberti? Without acknowledging or accepting the representation that the failure to get a separate and final judgment on this one claim wasn't an intentional ploy. I'm not suggesting that it was. What effect does the absence of a separate and final judgment or some other approval of an interlocutory appeal have on our ability to hear and decide the questions that you're presenting here today?
Well, I think the court has discretion to hear this if it wants to hear it. The Rule 54B requires an express determination, and that's clearly lacking here. So I guess
do you have a case that gives that supports the discretion that we have to overlook that?
Well, I guess no, I don't. I can't cite a case, but I guess I would say that if we had taken an interlocutory appeal from this to a single justice, and the single justice had reported it to the appeals court, I think referred it to a 3-judge panel, I think you'd have discretion to hear it. I think. I guess I don't know the answer to Your Honor's. I don't have a case.
Counsel, you don't have to answer this, but is there some reason why this case can't settle for the railroad giving the LESSARDs a utility easement and them agreeing to take over all the maintenance requirements? It just seems
Well, Your Honor,
plain.
this case was mediated extensively.
Okay.
And it did not settle. I mean, I have my views as to why it didn't settle on the court. I'll just leave it at that. The case was mediated by a former judge of this court. I think Judge Greenblatt, I think.
I'm sorry, what?
Judge Greenblatt, I think, was the mediator. It was a former appeals court justice. It was unsuccessful in settling.
All right.
Greenberg.
Greenberg,
I'm sorry.
yes.
Yeah, sorry.
Yes, he was a judge of our court. Okay, I'm glad at least an effort was made.
Thank you, Your Honor.
Thank you, Counselor. We'll hear from the plaintiffs.
May it please the Court, my name is Henry Lane, and I represent Richard and Carol LESSARD, the original plaintiffs and the appellees in this appeal. With regard to the Rule 54 question, I'll address that first as well. Contrary to my brother's suggestion, I would suggest that, in fact, Judge Piper complied with Rule 54. Unfortunately, he did not use the magic language, but if you read the actual judgment, he expressly indicates, that all remaining counts, have been disposed of, and the judgment can now enter. So it's actually page 15 of his judgment, and basically it does what Rule 54 requires. He's intentionally meant that to have this case go to final judgment for the reasons he sets out in his judgment. So, again, he didn't use...
But he doesn't use the magic words, there's no just reason for delay and of Rule 54B.
I acknowledge he did not use the magic words, and, having to do it again, and if it had, Alberti unfortunately came out not in a similar time frame as this case was decided, but ideally he would have used the magic language, but I think substantively he did what Rule 54 requires.
Well, how do we know he thinks that it's worthwhile having appellate review before the maintenance and the utility easement questions are decided? You'd think it'd be a lot more efficient for one panel to determine all three of those together.
Well, obviously, from the plaintiff's point of view, we had every confidence that it was going to go in our way, so we were satisfied, to take that risk. But more importantly, from the plaintiff's point of view, you have a retired carpenter and a retired school teacher who has to battle the railroad. Now, admittedly, the Grafton and Upton is not the Union Pacific, but nevertheless, it's a railroad. It has assets. It has the ability to crush neighbors, okay? And the risk to the LESSARDs was substantial. They're going to lose access to their house if they lose. So the expense is going out of sight, but they have no choice but to pay it. And so for their benefit...
So why would they want to have two appeals? Because the maintenance and utility thing will get appealed too, as opposed to just one appeal.
Admittedly, but it's a matter of strategy. They felt confident enough in their case that they were willing to take the risk to cut off the bleeding currently, knowing that if they lose, there may be more bleeding, but at least we cut it off.
I mean, even if you're right on the passage easement, if the railroad's right about the utility easement, then this house doesn't have any utilities. I mean, I don't understand how just getting the driveway settled puts your clients safe. I mean, I think I'm missing something.
Well, unfortunately, I don't have the reference for me, but the statute says if you have a right-of-way, you have the right to put in utilities. So they have the right to put in utilities under the statute. So that's not an issue, And of course, then you get into secondary issues like they've been there for 70 years, and the utilities have been there for 70 years. But again, the statute, I don't have the reference for the statute, but it does say that if you have a right-of-way, you have a right to put utilities in. So that's not really a risk for them. Utilities aren't going anywhere. And again, so from their point of view, it's basically an economic issue. You go through a full-blown trial, have to get witnesses and, take up time and legal fees, frankly, and to fight the railroad. And if...
Yeah, I just don't get how having this appeal stops any of that. You'll still have to do that when you try maybe the utility thing doesn't have to be tried, but the maintenance part of this case.
Oh, from the LESSARD's point of view, that if this court affirms the land court decision, the case is over. They have an unrestricted right-of-way over the railroad. Now, they have to maintain it themselves. There's no argument there. If they want more than a farm crossing, but that's not an issue. That's a risk they're willing to. That's a responsibility they're willing to undertake.
So why not dismiss the other counts with prejudice? If you're saying the case is over, which would make it final, then why aren't the other counts, the utility count and the maintenance count, dismissed with prejudice?
I guess there's always that small chance that Judge Piper was wrong. But it was very clear. He issued a final judgment. And the fact that LESSARD's could potentially bring a separate action, is there, but it's currently not pending. Those are claims that are not pending. And it was clearly Judge Piper's intention that, the judgment be final with regard to the issues that were adjudicated. And again, as I say, unfortunately, he didn't use the magic language. And, in retrospect, I guess should have asked him to do that, but we didn't. So that leaves us with the substantive issues. And I think, I don't need to say a lot. I think, actually, Justice Hand pretty much made the case in that respect. I think if you...
Well, she's just asking questions.
Excuse me?
She was just asking questions. I wouldn't assume, just from the questions that...
Let me suggest that she asked the right questions, but...
That she did. She always asked the right questions.
But with respect to the substantive issues, my brother makes a lot of the idea that we didn't meet our burden of proof, but essentially, that's off the mark. We met our burden of proof. We established we have an easement and right-of-way. We have a recorded, written easement and right-of-way to cross the railroad for access to the severed portion of our property, which happens to be where our house is. So the question is, the only question is whether the subsequent clause about the maintenance, which is limited to maintenance required for farm crossing, also applies to the initial grant, which is, by its terms, not restricted. And I think, again, if you look at we don't need to prove anything other than the written document. And the question for this court is basically, what does a written document mean? You have to interpret the text. There's nothing else we have to produce. We don't have to produce anything about what the circumstances were. We don't know. Nobody knows. But we have the text. We have the written document. We've proved we have an easement. Now, the extent of that easement, in our view, is unlimited. There is no limitation. It says we have a right-of-way and easement to cross the railroad to get to our severed parcel of land. That's all we needed to prove. The railroad's arguing, well, there's something more in that document that restricts that, but that's not the same as us not proving it. We've proved it. Essentially, if they want to prove it's something less than what the document says, I think the burden shifts to them. And again, to the extent that there is any ambiguity, our position is the ambiguity should be construed against the grantor. I mean, you can speculate that maybe Bridget Coffey wrote the easement. Unlikely as that is, there is a mathematical possibility that she in fact did, but that's not what the rule is. The rule is it's construed against the grantor, and the railroad was the grantor. Coffey was the grantee. So, the rule still applies. Ambiguities are construed against the grantor of the instrument, not the grantee. But I still think the strongest argument is that when you actually parse the text, you have the unrestricted grant of an easement, which is then described with respect to its location, et cetera, and its width, and then you get the language about the obligation of the railroad to maintain a farm crossing within the area that was the easement for which the easement was granted. So you have actually a time break between the grant of the easement and the creation of the obligation to maintain a farm crossing within that easement. So, you look at it in those terms, it's very clear. The easement's granted, and then the obligation to maintain a farm crossing within that easement is provided for. So there's clearly a disjunctive situation, and I think that's all we need to prove. So unless there are further questions, I have nothing else to add. And we'll rely on our written submissions.
All right, thank you, Counsel. The case will be submitted. I'd like to, that ends our cases for today. I'd like to thank our timekeeper. More challenges than usual. Our court officer, both the cross we have now and our stand-in earlier. All the attorneys already before us, and of course the clerk's office, without which we couldn't do anything. I think a shout out to our information technology department is also warranted in this case under these circumstances. I want to remind the interns that we're going to go off the bench, we're going to take off our robes, and then we're going to come right out to talk to you. So I invite all of you to stay and talk to us after this argument. And with all that said, court is adjourned until August 12th.